Okay, this video gives you a bit of an overview about how to read the chapters in your casebook. So this chapter on pleading is very much a model for the other chapters. It starts out with a section called Perspectives. And this information is the policy ramifications that underlie this particular area of the law. You'll notice that the online assignments don't focus on this perspective section. I'm not going to quiz you directly on this perspective section in the online quizzes. However, I want you to read this very carefully because this is the information that we'll focus on for class discussion in many cases. We'll focus on the policy implications of the particular procedural choices that the rule drafters and the courts have made. The other big thing to focus on, of course, is that this casebook involves cases. Conley versus Gibson is the first case. So typically it's going to take you longer to read a case than to read the introductory materials, the policy materials, because it's going to be a little bit more dense reading. So you should expect to spend more time with cases than with the other materials in the casebook. And as you read cases, I want to make sure you focus on the notes that follow the case. These are written by your casebook author, and they're designed to help you better understand the case. So you may, in some circumstances, want to potentially scan these notes and read them before you read the case. That might help you better understand the case. And then after you read the case, read these notes again and make sure that you're internalizing, you understand what the authors are getting at. If you don't understand it, go back and read the case again to make sure you're getting what they're talking about in the notes. These notes are designed to be a guide and a tool to help you better understand the case. Okay. I now want to focus on case reading itself. And many of your faculty, I'm sure, will talk about case briefing, and we'll have different perspectives on it in terms of the exact types of format they want. For my purposes, I want you to ask yourself 4 questions whenever you read a case. And during the first half of the semester, I would like you to actually write out your answers to these questions. If you want to stop after the halfway point, you can. Many attorneys in practice don't necessarily write out answers to all these questions, but because they've so internalized the process of answering these questions for themselves, they no longer need to write out answers. But these are things that are automatic in the way that attorneys read cases. So the first question is focusing on what court issued the opinion you're reading and when. And this is essential information for knowing whether the case is authoritative. So the Conley versus Gibson case, you can answer this question by looking, of course, at the case citation, which we see right here. And we see from the citation, this is a Supreme Court decision. The U.S. gives us that signal. And we also can see its date is 1957. So that tells us Supreme Court issued this opinion. It's going to be authoritative, of course, everywhere in the United States, because the Supreme Court of the United States is the ultimate authority on the content of federal law, and the Federal Rules of Civil Procedure are federal law. So the Supreme Court decision is going to be authoritative everywhere. But we do need to be a little bit careful because of the fact this is a case that's somewhat old, 1957. If there are any cases that the Supreme Court has issued after 1957, the more recent cases will control over this older case. And so we need to be careful and make sure we're focusing on the most recent case. And what we'll find, in fact, is that the subsequent cases that we'll read will indicate that part of Conley is no longer good law. All right, so that answers our first question. What court issued this opinion and when? The second question you need to focus on is the procedural history. What happened earlier in this particular case that made it necessary for the court to issue this opinion? And we focus on this information for 2 reasons. For one, it helps us understand the court's decision, understands what's at stake and what the court is being asked to decide, which helps us understand what they're writing in their opinion. It also, for our purposes of this class, helps us learn about civil procedure, because the process of how the case got to where it is largely the process of civil procedure. So it'll help us kind of think and get some practice identifying how cases work their way through the civil system. To answer this question, you're going to have to get into the meat of the case and actually read what the court's saying about why it's issuing this opinion. And so you would focus on, usually this is going to be in the early part of the decision. And I'll switch over here to photocopies so I can write on it. Here, in the first paragraph, the court's explaining how we got here, We have African American employees who were not treated fairly. They were discriminated against because of their race. And the court's explaining that they brought a class action to challenge this race discrimination. So, procedural history initially, we have a group of African Americans who experienced discrimination. They filed a complaint in federal court challenging the discrimination. The next thing that happens is that the defendants move to dismiss their complaint. And that's a common response to a complaint, is the defendants are arguing that there are problems with the complaints that require its dismissal. You notice here that the Supreme Court's calling them respondents rather than the defendants. The reason they're calling them the respondents is because at this stage in the appellate process, they're responding to an appeal. The plaintiffs are appealing, so we're talking about them being the responders to the plaintiff's appeal. But if you trace things back, you know that we're talking about the defendants who moved to dismiss the complaint. And the court explains their reasoning behind their motion to dismiss, and there were 3 reasons. They argued that the district court lacked subject matter jurisdiction. That's one reason. They argued that the plaintiffs failed to join the railroad as a party, and that's a reason for dismissal. And they argued that the complaint failed to state a claim upon which relief could be granted. Those are the 3 reasons that the railroad gave, arguing for the complaint to be dismissed. The district court responded to that motion to dismiss with its 3 rationales by granting it, gave the defendants their motion to dismiss the complaint, and the reason the district court gave was because of the jurisdictional ground. The district court concluded that it lacked power to hear this case. Then the Court of Appeals affirmed the district court's decision, so agreed that the district court lacked jurisdiction. And then there is an appeal then to the United States Supreme Court, and the United States Supreme Court concluded the district court was wrong, that it did have jurisdiction to hear the case. And then, interestingly, rather than just sending the case back down, as it really ought to have done, because the subject matter jurisdiction question is the only question that the district court and the Court of Appeals considered, the Supreme Court went ahead and decided the other issues that the defendant raised. The Supreme Court went ahead and said the railroad did not need to be joined. The lack of joinder of the railroad was not a grounds for dismissal. And then the Supreme Court went on to dismiss the 3rd argument, that the complaint failed to state a claim. So this is the procedural history of the case. And let me map this out quickly for you. So, class action filed in district court, alleging discrimination. Then a motion to dismiss was filed by the defendant, the union, for 3 reasons: lack of subject matter jurisdiction, failure to join the railroad, and failed to state a claim upon which relief could be granted. Three rationales behind the defendant's argument that the complaint should be dismissed. The district court granted the motion to dismiss based on the argument that there was not jurisdiction in that court to hear the case. The Court of Appeals affirmed that decision. The Supreme Court reversed that decision and concluded, nope, there in fact is subject matter jurisdiction, so that's not a good argument for dismissing the case. Under most circumstances, the Supreme Court would have remanded the case, sent it back to the Court of Appeals, and then back to the district court for purposes of deciding whether the other 2 arguments were valid or not. But instead, the Supreme Court goes ahead and decides the other 2 arguments the defendant raised. The failure to join a railroad, and said that wasn't a problem, did not necessitate dismissal. And then they focused on this failure to state a claim, which is the issue that we're concerned about for purposes of, and that's our reason for reading this case. I'm going to stop here and pick up with another video segment in a moment.